Judgment in the matter of Unger and another in substitution for Hasan against Ul-Hasan and another.
Lord Stevens will explain the decision of the court.
This appeal concerns an application for financial relief brought by Ms Hasan, the wife, against Mr Ul-Hasan, the husband, under Part 3 of the Matrimonial and Family Proceedings Act of 1984, following their overseas divorce. I will refer to that act as the 1984 Act. On the wife's application, the court in England and Wales was empowered to make any of the orders which it could make under the Matrimonial Causes Act 1973 if a decree of divorce had been granted in England and Wales. I will refer to this act as the 1973 Act. Prior to the final determination of the wife's application, the husband died. His death raises two important issues as to whether the wife's claim for financial relief can be continued not against him, but rather against his estate. The first issue is whether, on the correct interpretation of the 1984 Act, read with the 1973 Act, the right of a wife to obtain and the obligation of a husband to provide financial relief following an overseas divorce is a right personal to the wife and an obligation personal to the husband, such that on the death of the husband, the wife cannot continue her application for financial relief against the husband's estate. The second issue is whether a claim for financial relief following an overseas divorce is a cause of action which survives against the estate of a deceased spouse under the Law Reform Miscellaneous Provisions Act 1934. I will refer to that Act as the 1934 Act. Following her husband's death, the wife wished to pursue her claim for financial relief against the husband's estate. In the High Court, Mr. Justice Mostyn considered that he was bound by the decision of the Court of Appeal in Sugden against Sugden, but would otherwise have held that the wife could continue her claim against the estate of the deceased husband on the basis that the wife's unadjudicated claim for financial relief was a cause of action vested in her and subsisting against the husband's estate. He considered that the decision in Sugden was incorrect, but was binding on him so that he was compelled to, and did, dismiss the wife's claim against the husband's estate. Mr. Justice Mostyn granted a leapfrog certificate enabling an application to be made by the wife as appellant for leave to appeal directly from the High Court to the Supreme Court. This court granted that application. Before the appeal was heard, the wife died. Accordingly, the appellants in this court are the personal representatives of the wife's estate, and the second respondent is the executor of the husband's estate. The Supreme Court unanimously dismisses the appellant's appeal because, on the true interpretation of the 1984 Act, read with the 1973 Act, the rights and obligations to obtain and provide financial relief are personal to the parties, so that further proceedings cannot be taken against the estate of a deceased spouse. Accordingly, the second issue, as to whether a claim for financial relief is a cause of action which survives against the estate of a deceased person under the 1934 Act, does not arise for determination. The reasons for dismissing the appeal are set out in a judgment given by me with which Lord Hodge, Lord Hamlin and Lord Burrows agree. Lord Leggett gives a concurring judgment. Lord Hodge, Lord Hamlin and Lord Burrows also agree with Lord Leggett's judgment. I will now briefly summarize some of the reasons why, on the true interpretation of the 1984 Act, the rights and obligations are personal to the parties, so that where one of the parties has died, further proceedings cannot be taken. First, prior to the enactment of the 1973 and 1984 Acts, judicial decisions had consistently construed matrimonial legislation as creating rights and obligations which ended with the death of a party to a marriage and which could not be pursued against a deceased spouse's estate. Parliament is presumed to have had knowledge of that established orthodox understanding when enacting the 1973 and 1984 Acts. If Parliament were to depart from that orthodox understanding, then one would have expected there to be clear words to that effect in the 1973 and 1984 Acts. Rather than there being clear words departing from the orthodox understanding, Parliament used similar terminology to that in an earlier statute, which had authoritatively been interpreted as meaning that an application could only be made and proceeded with by one spouse against another, while both remained alive. Second, the orthodox understanding that financial provision on divorce only enables orders to be made as between living parties to a former marriage is also to be found in the provisions which Parliament enacted in relation to inheritance in the Inheritance Provision for Family and Dependents Act 1975. I'll refer to that Act as the 1975 Act. Section 14 of the 1975 Act makes special provision for a former spouse prevented from obtaining a share of the family assets in matrimonial proceedings by the death of the other spouse. Special provision was required because, in accordance with the orthodox understanding, the supervening death of the other spouse would prevent a court making an order for financial provision in matrimonial proceedings brought or continued against the estate of a deceased spouse. Third, if the rights and obligations under the 1984 Act were not personal to the parties so that they did not end on death, then it would have been unnecessary for Parliament to have amended the 1975 Act in order to enable a former spouse, by virtue of an overseas divorce, to make an application for financial provision in respect of inheritance. It was only necessary to make that amendment because the rights and obligations under the 1984 Act were personal, so that on the death of one of the parties, a former spouse could not proceed in a claim for financial relief against the deceased's estate. As I have indicated, in light of the Court's conclusion on the first issue, the second issue does not arise for determination. However, if the rights and obligations under the 1984 Act had not ended with the death of a party to the marriage, then I consider that earlier judicial decisions, insofar as they suggest that a claim for financial relief is not a cause of action within the meaning of the 1934 Act, cannot be supported. However, based on the outcome of the first issue, the appeal is dismissed.